G'day everyone, and welcome to the second video in week 8 of our admin law course. This week we're looking at merits review, which means we're looking at the work of the Administrative Appeals Tribunal, which was established specifically in order to conduct merits review, and which will soon be abolished in favour of a largely identical Administrative Review Tribunal. In the first video, we looked at the establishment of the tribunal under its own legislation. We talked about the bill before Parliament for the implementation of the new ART, and we talked about its jurisdiction. For the tribunal to have jurisdiction, you must be able to point to a provision in an enactment that specifically grants the tribunal the power to review that decision. In this second video, we're focusing on merits review. We're going to look at some of the challenges of merits review and then the remedies that the tribunal can provide. In the third video this week, we're going to have a look at some of the procedures that the tribunals use or will use. So, merits review. By now you're well aware that this is the process of determining whether a government decision was the right decision, whether it was the best decision. In one sense, this may seem like a fairly straightforward task, but it's not. The first thing we need to think about is whether there is an expertise deficit, and whether the tribunal can overcome that deficit. Administrative decision makers are often people who have specific expertise in their areas, and it takes years to build up that expertise. For instance, the Civil Aviation Safety Authority includes aviation experts who have thousands of hours of flying experience all around the world in all weather, in everything from gliders to large multi-engine long-haul jet planes. When one of those people makes a decision about, say, the suitability of a person to hold a commercial pilot's licence, how can the AAT hope to review that decision with any expertise? The Great Barrier Reef Marine Park Authority contains some of the foremost marine scientists in the world. A tribunal member might review a decision by CASA before lunch and then a decision by Gabrumpa after lunch. How can they possibly hope to make a better decision than the original decision maker? The truth is, of course, they can't. Inevitably, the tribunal ends up relying, at least to a certain extent, on the expertise of the original decision maker. The only real way which an applicant can overcome this expertise deficit is by obtaining the services of their own expert to assist the tribunal, but this can be very expensive. So there's one problem with merits review. The expertise deficit puts the decision maker at an advantage. Second, there's a fundamental question about precisely what the tribunal is meant to do. We know the tribunal is conducting merits review, but that could mean two things. On the one hand, it's review. So they could simply start with the decision made by the original decision maker and then ask whether that decision has merit. So the whole process of reasoning would be to test the decision that was originally made to see if it can be left intact. On the other hand, though, the tribunal's legislation puts it in exactly the same position as the original decision maker. That provision's found in Section 43, subsection 1 of the AAT Act. So there's no actual reason for the AAT to worry about the original decision at all. The AAT can simply start from scratch with what they call a hearing de novo, which means a new hearing. They can simply make the decision as though the original decision maker had never been there. The same power is found in Clause 54 of the bill for the new ART. The AAT's function has always been, effectively, to review the original decision, and the AAT has usually only made a decision de novo if there were new facts which were not available to the original decision maker. This happened in a case called Jebb and the Repatriation Commission, where a war veteran who had suffered a gunshot wound was seeking a pension. After the original decision was made, Mr. Jebb challenged that decision, and while the challenge was waiting to be heard, new medical evidence came to light which affected his entitlement to a pension. Now, if the AAT had simply been conducting a review, the AAT would have ignored that new evidence because it wasn't available at the time of the original decision. However, that would have made no common sense at all. So the AAT conducted, in essence, a hearing de novo, taking into account all the information, including the new information. The third issue with merits review is the extent to which the tribunal should be guided by policy. Policy is one of those words that people use but never really seem to understand. In this context, policy is a guideline or an expectation put in place to assist decision makers to make their decision, but it stops short of being an actual rule. Remember the learner-driver logbook example we were using for all those weeks? The one where the delegate had to review the logbooks of the learner-driver? It's not too hard to imagine some policies that might develop around those processes. For instance, there might be a policy that learner drivers who had spent more time in a manual car and less time in an automatic should be considered more ready to drive. There might be a policy that young people who had spent a lot of time having professional driving lessons should be considered more ready to drive. There might be a policy that young people who were driving consistently every couple of days for short periods would be regarded as getting better experience than someone who packed virtually all their hours into a 2-week period. You can see that these are not rules, not exactly, but they're definitely matters which the decision maker might be expected to consider. What happens then when that decision ends up in front of the tribunal? The policies are not formal documents. They may not even be written down. Should the tribunal take into account the policies of an agency? Well, in a case called Re a Visa Cancellation Applicant in 2011, the AAT had a bet both ways. It decided that it should consider policy, but that it was not bound by policy, so the AAT can depart from policy. That case was one in which an immigrant from New Zealand had lied on entry into Australia and had not informed immigration officials about his imprisonment in New Zealand for manslaughter and rape. He lived a law-abiding life in Australia, but when his past was uncovered, his visa was cancelled. The AAT considered a range of policy factors, such as the government's objective to protect the Australian community, and ultimately felt that it should be guided by those objectives. The applicant was denied a visa and deported to New Zealand. This relationship with policy is not explicitly stated in the AAT Act, and it's also not in the ART Bill. So until someone challenges this proposition, the most likely and most sensible scenario is that the ART will also be guided by, but not bound by, the policies of the decision-making agency. So there are some challenges of merits review. The tribunal inevitably has an expertise deficit compared to a specialist decision maker. The tribunal also needs to walk a fine line between merely reviewing a decision and making a new decision as though the previous one had never been. And finally, the tribunal should consider policy, but it's not bound by policy. None of these matters appear set to change when the new tribunal commences. If the tribunal undertakes merits review, it can do 3 things. These powers are set out in Section 43(1) of the AAT Act and Section 105 of the ART Bill. Each tribunal can affirm the decision under review, vary the decision under review, set the decision aside and make a completely new decision as a substitute, and send the decision back to the original decision maker, along with any directions or recommendations that it might have. This means, in short, that the tribunal can do virtually whatever it likes in relation to the decision under review. Let's look at a couple of examples. In a case called Castledine and the NDIS agency, Mr. Castledine had an NDIS assessment for his quite severe disabilities, but received a decision which he felt would leave him inadequately supported, and which did not reflect the rules under the legislation. He challenged the decision, and his views were supported by the medical reports from a range of medical professionals who'd been dealing with him. You can see that this overcame what I've described as the expertise deficit. The AAT agreed that the NDIS agency was making inadequate provision, and so they set the decision aside altogether and instead made their own decision on how many hours a year of each type of specialist support Mr. Castledine would receive. Frankly, I can't imagine a better example of what I've been banging on about this whole course. Here's a situation where a severely disabled man and his carer received a life-changingly bad decision from a massive government agency, and yet admin law meant that he could take them on and have the decision changed. People think it's boring, but seriously, how good is admin law? In another matter, Drake against the Minister for Immigration, the federal court found that the Administrative Appeals Tribunal had not been independent enough. In that case, the law allowed the minister to deport any person, not a citizen, who was sentenced to imprisonment for a year or more. Mr. Drake was sentenced to a year in prison for possessing cannabis, but with an order that he serve only 3 months. The minister ordered his deportation, and he appealed. The AAT found for the minister, and so Mr. Drake appealed even further to the federal court. The court found that the AAT had been too persuaded by the minister's line of thinking, whereas it should have exercised a more independent mind and remade the decision itself. From all of this, you can see that the tribunals have sweeping powers. They can affirm the decision, change or vary the decision, set the decision aside and make their own decision, or remit the decision to the original decision maker. In deciding what to do, the tribunal can take the original decision into account, but it can go beyond that initial decision, conducting a hearing de novo. It can consider matters of policy, and it should consider whether it's able to overcome the expertise deficit in order to make an informed decision. Powerful. So that's what Merits Review does. Next video, we're going to ask how they do it. How do the processes of administrative appeals tribunals work in practice?